Kenya's biggest conversation enters the second hour, 6 minutes after 7. City today's proverb.
When the roots of a majestic tree begins to decay, it spreads death to the branches. What I'd like to say, it takes a bit of time though.
So slow death.
Yes.
But once it's in, it's in.
No, once it's in, it's in. And the really insidious part of it is you actually never really get to know. If there's a storm and that tree is shaken, it may fall and you realize, goodness, you mean all along this tree had actually rotted the roots. But in the absence of a storm, you will actually begin to notice probably when the leaves keep drying and graying and yellowing and you wonder what is happening. Yes. That's when whatever death and decay had been spreading has reached its zenith.
What we are seeing in Kenya is the zenith.
I think it's reached as far as it
You think so?
Yes, it
possibly
has.
go.
It has.
I
It
think
has.
it's the decay that it has reached as far as it could possibly go.
So who are our roots?
Let's take the constitutional perspectives and understand that according to the Constitution, we, the people, we,
Are the tree or the roots?
we are supposed to be the earth on which that particular tree grows. And whatever route you're talking about will come through that particular earth to the tree.
Okay.
Yes.
Okay.
It's what the soil allows to take place that enables the germination, the growth, and everything else.
Yes.
And it's that same earth that enables that particular tree to have the infestation of decay. Same avenue, same route.
That's even more neat than the proverb itself.
You asked.
More cryptic than the proverb. A proverb with a cryptic definition.
The crypt.
The BBI happened on Friday, so the judgment of the Court of Appeal judges, and they read it throughout the day. They upheld some of the matters that had come from the High Court. How many of them? 14 matters. And then they set aside some 3 matters. They set aside the issue that the president has contravened Chapter 6 of the Constitution. They also set aside the fact that, the earlier determination that the Article 257.10 of the Constitution requires all specific proposed amendments to the Constitution be submitted as separate and distinct referenda questions. They also said the BBI steering committee established by the president and published in a special issue of the Kenya Gazette of 10th of January 2020 is unconstitutional and unlawful. They set aside that. They said, no, it was not unconstitutional. You don't have to take separate questions to the referendum. And the president did not contravene Chapter 6 of the Constitution. The other matters, 14 of them, they upheld. They said, yes, we agree with the High Court on these particular matters. Many of them, including that the basic structure doctrine is applicable in Kenya. It limits the amendment power set out in the Constitution. The basic structure of the Constitution can only be altered through the primary constituent power, which must include 4 sequential processes. And that is, start with civic education, then go through public participation and collation of views. Then you have a constituent assembly debate and ultimately a referendum. Anything else beyond that, you're breaking the law. Civil court proceedings can be instituted against the president, they said. The president does not have authority under the Constitution to initiate changes to the Constitution. That power is vested to the people directly or through their representatives in Parliament. The steering committee on the implementation of the bill, BBI, that's the task force, has no legal capacity to initiate any action towards promoting constitutional changes. The Constitution of Kenya Amendment Bill was unconstitutional and a usurpation of the people's exercise of sovereign power. The Constitution of Kenya Amendment Bill cannot be subjected to a referendum in the absence of evidence of continuous voter registration by the IEBC. The IEBC does not have the requisite quorum. At the time of that launch, there was no show that the collection of endorsement of signatures, there was neither legislation governing the collection, presentation, and verification of signatures, nor an adequate legal and regulatory framework to govern the conduct of a referendum. Many of these matters were then brought before the judge, and this is what the judge said. So what does that mean? We bring in our man on the ground, and this is constitutional lawyer Waikwa Wanyoike, who joins us via video link. Good morning, Waikwa.
Good morning.
It's good to have you again on the show, and thank you very much for joining us.
Thank you for inviting me back.
Let's start by just understanding some of these terminologies now that we have the benefit of having you on the show. We saw you tweeting on Friday and telling people, look, this is not a ruling, it's a judgment. What does that mean? What's the difference?
That was just a light moment, but there is a distinction in law. So what I was saying is that what we were getting from the court on Friday was a judgment, not a ruling. Ordinarily, a ruling is a decision made when the matter is still going on in a court. So, for example, when you have an injunction stopping somebody from doing anything until the matter is decided, that's a ruling. Mm-hmm. When you have, for example, in the BBI matter at the Court of Appeal, when you had different parties being admitted, that's a ruling. But when that court comes to the end and renders the final decision, that is called a judgment. That is the explanation or the clarification I was making.
Okay. Good to know. Good to know. So a number of things that were upheld from what the High Court judges had said, and then they also set aside a number of things. Overall, is this a win or a loss for the proponents of the BBI?
It's a loss for the proponents of BBI. So we start with what did the proponents of BBI want? They wanted to make constitutional changes supposedly before the 2022 general election, and the BBI bill was the tool or the instrument that they were going to use to effect those changes. What the court has said, and it's good that you've read the orders of the court, is that even though there were reversals, about 3 reversals of the High Court findings, still the bill cannot go to a referendum. And so to that extent, then BBI has nothing to take to a referendum. The bill is dead and the process is dead. So in my own estimation, then I would say that's a significant loss for the BBI proponents, but obviously a very, very big win, not so much for the people who argued to block BBI, but for the Constitution itself.
There's already talk, that, what we're seeing today is that the Attorney General is then requesting for copies of the judgment to then look through it. And he says, according to him, that there are some 3 sticky areas that he wants to be able to go through. After having gone through, then, that would then furnish him with necessary action to then go to the Supreme Court. But it is an option for him right now as he sees it. What do you think of that?
Yeah, I think the Attorney General is looking at the possibility of going to the Supreme Court, and my understanding is closely looking at 3 issues. The first issue is on basic structure. The second issue is on popular initiative, the fact that the Court of Appeal confirmed what the High Court had said, that the President or any state officer or public officer cannot use the popular initiative route to amend the Constitution. And the third, which is what I think they're really keen on, I doubt that they're so keen on basic structure and popular initiative, especially knowing that the term of Uhuru Kenyatta is coming to an end very soon. But the one that they're keen on is the third, which is the fact that the court confirmed again what the High Court had said, that the President does not enjoy immunity.
He says he wants to look through these, Waikwa, and from from your point of view, I mean, you had said previously that, this thing it's finished, it's dead. But there seems to be some kind of life upon which the Attorney General can pick up on and say, look, it's not dead, that we still have an opportunity to get this thing going. In your opinion, do you think that it's worth, the effort?
So, there has always been two sides to BBI. The first side is the political, which is what Uhuru Kenyatta and Raila Odinga and their primary supporters were interested in. And people should know that the main reason these people have been pushing BBI is so that they can create this expanded executive. And we can already see how the judgment is causing them difficulties as they try to craft alliances. So there is that political side of BBI. But there is also the legal side, which is the very technical issues that have come through the court, whether it's a question about basic structure, popular initiative, and others. Those are legal issues. My own view is that the political side of BBI has died because the political side of BBI is tied to 2022 elections. And now it has become untenable. And that is why you saw Raila Odinga come out very, very quickly and say that they are no longer interested in pushing this to the Supreme Court because he has a presidential campaign to run. So he was being very smart about that. But the legal side of BBI hasn't died. And in fact, I would be so surprised if we don't have this matter go to the Supreme Court. Remember, it's not only the Attorney General who can appeal. There are so many parties in this case. So any of them can appeal. And the moment one appeals, the Supreme Court has to take jurisdiction because this is the kind of matter that you don't need the permission of the Supreme Court for it to hear the case. Any appellant has what we call appeal by right to go to the Supreme Court and have the cases determined. And the moment you just have one person, whether that be the Attorney General, whether it's the citizen who was very good at the Court of Appeal, Mr. Aruchiel, or anyone else, then all the other parties are dragged to the Supreme Court. And what is likely to happen at that point is you see parties doing what we call cross-appeal. So they raise the issues that they were not happy with themselves.
You've said there's a political side of things and then there's a technical legal side of things. Now, how do we distinguish them if we look at through the whole process? There's the handshake, which is the political deal between these two gentlemen, the president and the leader of the opposition, on saying, all right, I'm going to recognize you as the president and I'm going to tell my supporters to do the same. And then there's the BBI, which they said was breathing life into that handshake and saying, we have shaken hands and agreed to bring peace, but then we're going to use the BBI as a process to bring that conversation to the people so that the people can discuss what is it that leads us to this kind of situations every 5 years after an election. And then the BBI gives birth to this Constitution Amendment Bill. Now, if you look at that politically, did the judges raise an issue with any of those steps, with the handshake, with the political need to then have a conversation, the BBI, the setting up of the task force, or even that task force coming up with what they were calling the proposals of the people to amend the Constitution?
A few points. First of all, how do you distinguish between the political and the legal? My own way of distinguishing them is the political is perishable and it's opportunistic. And that is why it was driven by the politician. And by what I mean by that is the politicians will not be interested in the issues they were raising on BBI if there is a much more significant issue they have to deal with. And at this point, it's the 2022 elections. Of course, they're still interested in finding a formula of creating more position. But that position is perishable because it wasn't based on any principle. It was based on political opportunism. But what the technical legal issues mean they entail posterity. Remember, Eric, when the judges say that the Constitution has a basic structure, that is not speaking BBI. It is speaking to how Kenyans will be able to go about amending the Constitution 15, 20, 60 years from now if we still have 2010 Constitution. When Raila Odinga, Uhuru Kenyatta will never be anywhere in the scene, maybe even in terms of how much they will be remembered. So the technical goes to the posterity issues, the issues about the Constitution and the survival of the Constitution and constitutionalism. And the reason why the judges have been so detailed, both at the High Court and the Court of Appeal, is because they realize that the politicians are using their opportunistic, very selfish agenda to try and tamper with something that will leave the Constitution in a very bad state for a very long time. So that is how I would make the distinction myself.
I'm asking that because we know that as the amendment bill was going on, there was also this other route of attempting to amend the Constitution through Parliament. Bills have been published and bills are ready in Parliament. Now, does the judgment of the Court of Appeal judges affect that process in any way? For example, even whatever they were saying, the basic structure doctrine, or the issues of there being no modalities of how to conduct a referendum, the constitution of the IEBC, would any of that mean that even the parliamentary route is therefore also halted?
Yes and no. Yes, because now what the judgment of the Court of Appeal does is that it provides the basic minimum that anybody wanting to amend the Constitution has to comply with, whether it's through parliamentary process or through a popular initiative. Of course, there are issues that speak to popular initiatives specifically, but let's take basic structure, for example. The judgment of the court in regard to basic structure affects how Parliament amends the Constitution going forward. If, for example, any of the things that Parliament is proposing to amend, I hear Jeremiah Kioni has identified, I think, 51 issues that they would want to amend through the parliamentary process. If any of those touches on what the judges are referring to as basic structure, then the Parliament will be required to follow the four-part process that you're talking about. When it comes to IEBC, for example, if there is a problem with IEBC in terms of composition, and there is a need for referendum to pass the parliamentary bill, and IEBC is still not quorate, then that judgment will have an impact or will be used as a basis to challenge the competence of IEBC to hold the election. What basically has happened now is that the judges have clarified the rules for constitutional amendment. And the politicians actually were not crafty about this. And we talked about this a while back, because the politicians unfortunately thought they would bulldoze everything through, and they never followed the law or basic logic that flows from the Constitution. And so what they've done is, by forcing or trying to force constitutional amendment, and then causing people to go to court, and the court getting really engaged in terms of interpretation, they've forced the court to set or to articulate rules that actually makes it much more onerous for them to amend the Constitution. And now trying to do it through parliamentary process won't cut it. They still have to follow the rules. And in fact, they should start by passing the legislation that they were told that they have not passed up to now.
Let me just get it right. So what we are saying is, based on what the judges of the High Court and the Court of Appeal have said, to amend these several clauses and chapters of the Constitution that are now considered the basic structure, even if you go through the parliamentary route, you must do this four process. You must do civic education, go through public participation, and bring a constituent assembly, which means that you have to do some bombers of some sort, even if it's going through parliament?
Yes, essentially that's what the judges are saying. The judges are saying, look, if you will want to change the constitution fundamentally, which is what really touching on basic structure means, to change the identity of the constitution. And by the way, it's not really about chapters, it's about issues. So just to give an example, you don't find any chapter in the constitution on separation of powers. In fact, it's so interesting, you never find the word or the phrase separation of power in the constitution other than in respect of county government. Yet it's such a sacrosanct and an ingrained principle within our constitution. And that would form part of the basic structure. So if you have to do anything that affects separation of powers, then you're touching on basic structure. So for example, changing the constitution so that you can reintroduce the possibility of members of parliament becoming cabinet ministers, you're already touching on the principle of separation of power, you're touching on basic structure, then you are required to follow the four-part process because now you've gone to the place where you need the four-part process. If you're making minor amendments, what judges said are corrections to enhance the constitution, not to dismember it, then at that point, you may not need a referendum, you may not need the entirety of the four-part process.
It's on that particular note that I want to come in, Mr. Waikwa, because you told us very, very clearly and very eloquently that many of the issues in the BBI did not actually require a constitutional amendment or a constitutional change. Now, if with the ruling that we have, Parliament embarks on trying to see this come to fruition, would they first be required once again to ensure that they have put in place the legislation that provides the framework from within which this can be operationalized? Or is it just something that they can follow the normal procedures that they normally follow in Parliament when they want to make something, when an idea is germinated into a bill and eventually becomes law? What happens?
So there are, I agree, CT, there are quite a number of things in BBI that actually don't require constitutional amendment. Even some of them don't even require any legislative changes. So just to give you an example, changing the amount of money that goes to counties from what they've been receiving to 35%, that can be done administratively. Because you already have the PFM, the Public Finance Management Act, you have the County Government Act, you have the legal framework, and you have the Constitution, which says not less than 15%. So as long as you have those laws, you don't even need to change the law, leave alone the Constitution. Of course, the issues that the politicians are really interested in are the ones that must require constitutional change, and in fact, not just the constitutional change, but they're the issues that touch on basic structure. And I keep insisting, for example, being able to pad government, being able to have MPs become cabinet ministers, those must go through a constitutional amendment, and in fact, they touch on basic structure. And the court, and if you listened to the president of the Court of Appeal, he used a very specific and deliberate term. He said what the politicians or what BBI had done is to pack the bill with sweeteners so that the people can rush to get those sweeteners, not knowing that the sweeteners are just lacing suicide bill or a suicide pill, and that is exactly what BBI is. So if the politicians, for example, really meant what that they really wanted these changes, for sure they can. There are a lot of things they can do even without a recourse to legislative changes. And the other example, for example, there was a lot of talk about youth, even though that proposal was contained in the legislative changes. So, for example, things to do with higher education loans board. Those don't even need legislative changes. Those just require administrative action, and some of these things will come to fruition. So if they really mean what they say, then they should have done a lot of these things even without having to force BBI through.
But leads me to ask the second question. With the time we have left before the elections, does our constitution actually give us a legal standing within which or from which the politicians can actually start the alternate processes, rather, not promises, lovely Freudian slip there, processes that would enable them to achieve what they wanted to achieve? Do we have the time?
So just to be clear, there is nothing that stops anybody from proposing constitutional amendment at any time, even a week before Parliament term comes to an end. There is nothing. And so if politicians want, for example, to pursue the bill that Kioni is talking about and others are talking about, nothing stops them from doing that. But when you come to the pragmatic of it, it becomes untenable. So, for example, once you go parliamentary route, remember there is a requirement that between the first reading and the second reading, you must let the bill sit for 90 days.
Yep.
That time was put there by the Constitution so that Parliament can facilitate adequate civic education and public participation. And so when you think about it, let's even assume they table this bill next week. Then you won't be touching the bill again, or Parliament won't be touching the bill again until December, maybe January next year. And then when you think about it from a very pragmatic level, how many politicians want to be running their own campaigns for the election and also running a very unpopular constitutional amendment? And especially knowing our record that nearly 70% of members of Parliament are voted out every time. So the pragmatics don't add.
Okay. Having a conversation with constitutional lawyer Waikwa Wanyoike on what the BBI judgment means, what next for the proponents of the BBI and also for everybody who had taken this matter to court. This is Kenya's biggest conversation, the Situation Room. The numbers, just like Waikwa is saying, those matter. If you look at what you need to do and campaign for an election, it matters what action you take now.
Just to remember that thousands of lives are lost on the roads every year, while many more are left dealing with the devastating effects of some of these accidents, some of these crashes. The majority of those can be avoided and they're attributed to human-related behavior. So we're looking at things like speeding. We're looking at things like, drink driving, dangerous overtaking, distracted driving, which can be avoided, failure to wear your seatbelt, lack of safety gear, such as helmets and reflector jackets while riding bicycles or motorcycles. So we're saying we're addressing these challenges presented on our roads, and we're calling on every road user to play their part, as everything can change in just a split second, but then you're dealing with the repercussions for a lifetime. Usalama barabarani. It starts with you, it starts with me. Fikeni salama, it's a message from the NTSA and the European Union.
Continuing the conversation with Waikwa Wanyoike at 21 minutes to 8 o'clock, constitutional lawyer. So looking at the import of the BBI judgment by the Court of Appeal on Friday, what this means. Waikwa, politically, there's what the BBI sought to achieve and sought to address. The 9-point agenda that the two principals set forth when they were forming the task force and saying these are the issues that we see we are facing as a country. From issues of ethos to issues of inclusivity to devolution, safety and security. All these matters are still out there that need to be addressed. Let me just speak on the issue of inclusivity, which is, one of the things that they were saying was the reason for expanding and changing the structure of the executive and the legislature. Having members coming from the legislature going into the executive and vice versa. What is it that we need to do then to address that? Do you think there's an issue of inclusivity that needs to be addressed in Kenya?
Whether there is an issue of inclusivity that needs to be addressed in Kenya, of course there is, but it's not what the politicians are telling us. The kind of inclusivity that we're talking about is what the Constitution has already identified. Remember, under the provisions relating to public service, and specifically, I think, Article 232 onwards, the Constitution talks about how the public service should look like, and that the public service ought to be extremely inclusive, whether it's regional, whether it's ethnic, all that type of inclusivity. But what have we seen in terms of public service? Public service still is very, very skewed. You find that certain communities are overrepresented, even when you take statistical analysis based on how big communities are. And that overrepresentation seems always to be skewed based on who the leader or where the leader comes from in terms of the community. So, for example, the Kikuyus under Uhuru Kenyatta have been overrepresented as a community statistically. And that also did happen during Moi's time. So, but you don't need to amend the Constitution to be inclusive. That just needs to be something that leaders do, the public service gets involved in. Let's talk about the other kind of inclusivity, which is, for example, gender inclusivity at the level of parliament. Again, there's really nothing much, there's not much that needs to be done in terms of constitutional changes to be inclusive. Political parties are not playing their part. Political parties are still very paternalistic. They always nominate majority of men, even when the law and the Constitution actually requires otherwise. So that's not the issue. Then even when it comes to positions, for example, cabinet and such, inclusivity is not just about you being called a prime minister and getting the largest motorcade. It's about inclusivity when it comes to substantive power. And so when you have cabinet ministers who are just rubber stamps and they cannot question what the president says, or when you have parliamentarians who have become sort of like a choir for the president, then it doesn't matter how many positions you create, as long as there is that one position of president. So let's talk about substantive inclusivity, not cosmetic inclusivity. Right. And what BBI was proposing to do by adding position, that is just cosmetic, and again a sweetener, as the president of the Court of Appeal calls them, so that communities think, oh, because one of our own, Mudavadi, Kalonzo, whoever, has been appointed maybe a majority leader or anything, that means anything. It doesn't.
Waikwa, for some crazy reason, all of this then became a competition between 3 or 4 individuals, like who was going to win. And so even when now we were privy to this, 12-hour reading of the judgment on Friday, there were individuals in different and groups of people in different pockets of the country, and it really became a competition between two sides, as opposed to really looking at the constitutionality and, essentially rights of Kenyans in terms of how laws would change that govern them. Now, as I look at this, I became more aware that, there was a lot that was not understood by this entire process by the majority of Kenyans who at some point would have been subject to voting on this thing. There was a lot that went under the carpet. And had it not been that it went to court in this matter, in my opinion, there would have been even much more that would have been lost for the comprehension of people. Where then does civic education, public participation play a role? Because for me, it blasts a hole wide open in terms of what ought to be done for Kenyans to really understand what guides them, the laws that guide. Because this can be usurped by, as we clearly see, by a very small group of people. And then things just go by without people really being involved in these processes.
I think that's what the court recognized, that what's happening. And in fact, one of the judges just said as much, that, and this goes back to the issue that Eric was talking about, how many points agenda that brought about the handshake. How much of that was actually driven by what people thought was ailing the country as opposed to two individuals, for example. And so when you have your own conversation as politicians, and especially not just all politicians, it's actually two individuals. We know, for example, very senior politicians who were willing to go against the grain, but they couldn't because they feared that they are risking their political careers. So this is not even a politician's issue, it's a two-man issue who decide this is what is the right thing for the country, and so they will be extremely prescriptive. But that actually goes against the values and principles of the Constitution, and especially participation, because participation actually underscores the agency of the citizen, and that the citizen actually understands what they need and what kind of good governance they want, and especially once they are provided with the information. And so, to your question about the role of civic education in some of these, that's precisely why the court is insisting. If you have to change the Constitution, and constitutional changes are enduring, you cannot just come and tell the people, we have reggae, and the reggae will continue or it won't continue, and you have to vote, and that's it. And you're not telling them what benefits they get out of that, what are the options there are, and why you have chosen one option or you're recommending one option over the other. And I have to say also the media is largely to blame, because the our media actually really likes dichotomizing issues and dichotomizing issues based on individuals. So at the end of the day, you hear this was a win for Ruto and a loss for Raila. That's not true. And it's actually quite offensive, especially to a lot of the young lawyers who have been arguing against BBI. And I know that team very, very well. I know there is no linkage. A lot of them have never even seen or met Ruto. And so for people to be saying that this is a Ruto versus Raila fight, it's not true. In fact, I don't doubt that actually Ruto would like an expanded cabinet, and he would like MPs in cabinet, and actually Ruto would like a lot of things in the BBI bill, and if he was not feuding with Uhuru, he would be on the other side. He's not taking these positions because of principle. No, it's just political opportunism. So it's unfair to citizens, and it's unfair to professionals when everything is dichotomized and becomes this is Ruto versus Uhuru. I saw the headline in The Nation, I think it was yesterday, which seems to suggest that this was a big win for Ruto. And in fact, I also find it extremely unfair to the judges, because it seems to send the message that the judges were doing what Ruto likes. Ruto doesn't even believe in what he says himself. And this is the tragedy of our politicians. So I find that there is need for Kenyans to be informed. Government has an obligation. If you go to County Government Act, county government have obligations to conduct civic education. On a matter like this, they needed to take a lot of time to educate Kenyans. IEBC has a mandate, independent commission, and then let them know what is being proposed, what different models are available, why it's necessary, and then they can decide whether they want to support it or not. But let's not dichotomize, let's not reduce every issue and to Araira, Ruto, and now whatever Okoa is, or whatever the name is for the new outfit.
As you mentioned, the IEBC Waikwa, there's a lot of chatter currently about then the role and mandate of the IEBC as currently constituted, and what this ruling essentially would mean for, saying, at any one time, in order for the IEBC to carry out its mandate, there must be at least 3 or 5 commissioners here and there. What does it then mean, as you see it plainly from this judgment, that the IEBC cannot do? And then what would it then have in terms of the recent by-elections that took place, their validity as currently constituted with this judgment? Can the IEBC carry on its duties? Or will those activities carried out by the IEBC in this period before now then be valid?
Yeah, that's a really interesting question, because I think there has been confusion about what the court has said, both the High Court and the Court of Appeal, when it comes to IEBC. So if you look at what was said at the High Court said that there are certain matters that IEBC deals with which are policy matters, and there are certain matters that are administrative matters. Things that repeat themselves over and over again, that don't require decisions of commissioners every minute, those are administrative matters, and those are done by the Secretariat. And what the court was saying is that when it comes to the administrative matters, those matters, because they don't require policy decisions of IEBC commissioners, and in fact there is already sufficient regulatory framework, both regulatory and administrative framework. They are carried by the Secretariat. Quorum doesn't affect those matters the same way, in legal sense, the same way it affects a very novel matter where IEBC, for example, has to decide, has a sponsor of a popular initiative met the minimum standards required, and especially in this case where there is no law that regulates that process for IEBC, and in fact, even the administrative procedures they had tried to come up with, they did that through illegal means. And so this has no, in my own opinion, and looking at reading the judgment of the High Court and then listening to the Court of Appeal judges, it has no implication to some of these issues to do with by-election. It has implication to do with issues to do with verification, the policy decisions around how to verify signatures, registration of voters in the context of referendum, and also the conduct of referendum, which was going to be the next major thing that IEBC was going to do. Actually, 2 major things. Formulation of questions, which again is a policy issue, or questions, and then conduct of referendum. And those are things that IEBC, even though there is the question about legality, it is not constitutionally, and I want to emphasize this, it's not constitutionally competent to undertake those things, because they are policy decisions that can only be undertaken by a legal and querate IEBC. I want to make one more point before I leave the IEBC point. The judges said something extremely fundamental about IEBC. They noted how IEBC has been struggling with its quorum. The law has been very clear in terms of how soon IEBC commissioners should be recruited, which is within the president making a declaration of vacancy. I believe it's within 7 days of the vacancy, and then conducting recruitment. And partly why the law is written that way is to make sure that IEBC doesn't face significant quorum issues. But IEBC, it seems like IEBC, and of course the Attorney General did nothing about it. The President did nothing about it. And so the issue about IEBC lacking quorum is actually as a result of the delinquency of IEBC, the Attorney General, and the President. And you can't come back and start arguing that IEBC should be allowed to continue with its work when the Constitution has specific standards and the law has specific standards about quorum for such a significant commission. And for IEBC to come to court and support that issue, that was very telling about its lack of independence.
There's this issue of civic education, Waikwa. It's a big one. Now, how do we define civic education and how do we distinguish civic education from public participation? Because like now the judge has said this sequence has to start with civic education and then you go into public participation before you go into a constituent assembly. How do you distinguish those two? And what's the threshold for each?
So civic education largely involves providing citizens with adequate information, going to find information that is relevant to a subject matter, bringing that information to citizens and packaging it in a way that citizens who have different capacities are able to understand it. And so, for example, you had even during the judgment the question of language coming up about whether just having something in English, also issues to do with just having things in a portal that is sufficient for certain purposes. But civic education specifically means providing citizens with education about civic matters without telling them this is what you will do. Participation is where now they come and tell the policy makers and their leaders that based on now the information I have, this is the decision I've made, and this is what I'm requesting you to do. And so that process of citizens now engaging with their with leadership and having the conversation about what they want done, that is what public participation largely is about. And that's how I would distinguish the two. And if you go again to County Government Act, because remember under the fourth schedule, which is the schedule that divides functions between national government and county government, county government have been given that role. And so they should at least have been given the opportunity to facilitate civic education in respect of constitutional proposals that were being made.
Waikwa, always a pleasure having you explain these things to us. We hope to catch up with you again soon.
Thank you for having me again.
No, thank you very much.
Asante sana.
This is the Situation Room, the only way to start your day.